Good evening, everyone. Welcome to Asala's Classroom Talks, where we mentor future lawyers, we foster critical thinking and simplify the law for the law students, for the lawyers, as well as the general public. Today, we are very excited to have as our guest one of the most coveted judges of our Supreme Court, Justice Lenaola, who is joining us tonight to simplify some of the difficult questions in civil litigation. So most welcome, Judge.
Thank you very much.
Yeah, and I just want to encourage everyone who is in the room to please write your questions in the comment section so that once we are done with the discussion, we can answer all the questions, hoping that time will allow. And also remember to subscribe so that you get notification of our future discussions. So, Judge, you occupy one of the most coveted offices in the land. Perhaps you can start by telling us, who are you and what has been your journey to where you are today, briefly.
Thank you very much, Dr. Isaac Lenaola. I'm now a judge of the Supreme Court. I graduated from the University of Nairobi on the 22nd of October, 1990. So this is my 35th year since I left the University of Nairobi. Mm-hmm. In between, I got admitted to the bar on the 19th of September, 1991. So this is my 34th year since admission to the bar. I became a judge after 13 years of practice, where I specialized in commercial and land law. But I was appointed at a very young age to join the High Court on the 28th of October, 2003. And on the 30th of October, 2016, I joined the Supreme Court as a judge of the Supreme Court. In between, I served as a judge and deputy principal judge of the East African Court of Justice in Arusha. I was appointed there on the 1st of July, 2013, and I left 2010, and I left 2011, and I left on the 1st of July, 2018. In 2013, April 16th, I was appointed a judge of the Residual Special Court for Sierra Leone, where I still serve. And I was elected vice president of that court last year, 2024 March, in Freetown, Sierra Leone. So that's my journey from university to where I'm seated today. And I thank you for inviting me to this interesting conversation.
Thank you, Judge. And it's a privilege, really, for us to host you tonight and just to have this discussion with you, with this immense wisdom, where we know it will go a long way just mentoring the young lawyers and the future lawyers of tomorrow. So, Judge, you have told us your journey, really. Maybe if you can quickly just tell us, what exactly do you think contributed to you becoming who you are today? What is this that you'd like to advise young lawyers, to hold on and to lose in order to get to where you are today?
I have no doubt that I'm here because of hard work. I have never compromised on working hard to achieve what I want to achieve. I'm one of the judges who are well known for sitting long hours when I was in the High Court. Everyone knew at the Milimani courts that I would be in the building before 6 in the morning. And I would leave when I'm done with my work for the day. So there's no compromise for hard work. Number two, there's no compromise for integrity. The fact that I did not go to the Court of Appeal from the High Court and rose straight to the Supreme Court meant that there was something right I was doing. And when I applied to join the Supreme Court without going to the Court of Appeal, I'm certain that my integrity went ahead of me. And number three, it is important that you have a support system. Even as a young person, I sought to sit with, discuss issues with older people than myself. So mentorship has brought me this far. I was one of the lucky people to have had the privilege of being friends with the late Charles Njonjo, the late John Keane, the late Olenti Mama, and other leaders in this country who are known for their wisdom. And I was very lucky to have mentorship. So for young lawyers and those at the university, you must seek to have a mentor, somebody who can guide you, especially for this generation. Because the difficulties of this generation are probably not the ones that I faced in my time as a young a student and also as a lawyer. So mentorship is very important. And lastly, I have no doubt that being where I am today is partly because I also took opportunities that came my way. I mean, when I got the opportunity to apply to join the Residual Special Court for Sierra Leone, I could have chosen not to, but I did. And I was interviewed from New York and I got the job. So again, when you see an opportunity that you think you can fit into, do not wait to be pushed. Do not wait to be given. Do not wait to be offered. Look for opportunities and take them. And I've given every opportunity I got a chance, and here I am.
Thank you very much, Judge. I'm sure our students have taken the lessons home. Now let's get into discussing civil procedure. And as you know, civil procedure is very elaborate. And just for starters, Judge, maybe help us understand what is the distinction between civil litigation and criminal litigation? What exactly is the difference between these two?
Well, thank you for my first year law question, but I guess somebody will learn from what I'm going to say. Civil litigation is the law around civil law, issues of personal law, issues of constitutional law, issues of contract, issues of tort, issues of family and succession, land and environment, debt recovery, and money claims. These are issues that do not have the criminal element, which we know to be that for there to be a criminal case, there must be the act, and then there must be the intention to commit the crime. So the difference is that simple. And all this grew out of common law, which is the law that we inherited from our colonial masters. And so that is the subtle, clear difference between these two areas of law.
Okay. And with your immense experience at the courts, from the High Court to the Supreme Court, perhaps help us understand what exactly are the differences in civil litigation in the High Court, in the Magistrate Court, in the Court of Appeal, and Supreme Court, just generally?
So generally in Kenya, and I was very lucky to have been a member of the Constitutional Review Commission of Kenya, which drafted the current constitution. So I know how we crafted Chapter 10 of the Constitution. The simple difference is that the High Court under Article 165 is the court that has the widest jurisdictional limit, because the High Court has got unlimited original jurisdiction in both criminal and civil matters. But for magistrates courts, the difference is that they do not have the same unlimited jurisdiction. So theirs is both geographical and pecuniary. So that, for example, in civil cases, a chief magistrate would only handle cases that are up to 20 million. Senior principal magistrate up to 15 million. Principal magistrate up to 10 million. SRM 7 million. RM 5 million. And then the small claims court have something a little lower. The High Court also has appellate jurisdictional matters from the magistrates' courts and also from tribunals. But you also know that we have other courts under Article 162(2) of the Constitution, which have do not have the same jurisdiction as the High Court, but they have courts of equal status. And the reason is that we were looking for specialized courts to handle environmental land matters and also to handle employment and labor relations matters. And so these three courts at that level are the courts that then feed into the Court of Appeal. And the Court of Appeal receives appeals from all these courts without any exception. But for the Supreme Court has got a circumscribed jurisdiction. It's got a limited jurisdiction. And one is, under Article 164(3) of the Constitution, the Supreme Court handles matters of constitutional in nature from the Court of Appeal as a matter of right. And any other matter where the Court of Appeal or the Supreme Court has certified the matter under Article 164(4) of the Constitution as involving matters of great public importance. So what differentiates our courts simply is jurisdictional issues. What kind of cases can one court handle which another cannot handle? That is, in a nutshell, the difference in jurisdiction in our courts.
Okay, and now let's look at the difficult question of jurisdiction. And quite a number of issues have arisen because of the jurisdiction question. And one of the most recent concerns that have arisen is with the issue of adverse possession.
Yes.
Before we look at exactly, the jurisdiction over this particular issue, what would you say, Judge, is adverse possession? And do we really live this particular doctrine today, given the recent evictions?
So in common law, adverse possession is a doctrine that developed over time, because in old England, there were people who are landowners and there are those who are not landowners. There are those who are serfs, those who worked on land which they never owned. But at some point, an interesting phenomenon arose where I would own land, you would come and work for me. But what then happens is you stay on my land as you develop it, you farm, you till, you build a house. And then the law developed to the extent that it became necessary for such a person to claim ownership of the land they occupy forcefully. And so the word adverse speaks to the fact that you are possessing land adversely. It's not your land as a matter of right. It's a land you're possessing and occupying and tilling and working on forcefully. Now, when we developed our law in Kenya, it was then determined that if you sit on my land forcefully, I've tried to evict you, have refused to go out, and 12 years have passed, you can then go to court and say, I need this land to be registered in my name because I've occupied it adversely. And that is a simple doctrine of adverse possession. When the Land Act today was developed in 2012, community land issues also arose and public land issues arose. And therefore, if you occupy land for 30 years in public land, which is public land, again, you can claim adverse possession. But for private land, it still remains 12 years.
Okay. And
the question whether it is still in place. It is, of course, in place. And the issue of evictions must be understood in the context of the larger land question in Kenya. Evictions from where? If you're in a government forest, say the Mau, and you're evicted from the Mau, what claim do you have of adverse possession? But if you're on my land, a private landowner, and you've been there for 12 years and you can prove that you have sat there for 12 years without a break, and I've been unable to remove you, our courts are churning out adverse possession judgments every single day. So the Environment Land Court particularly, I don't know any judge in that court who has not churned out a judgment both favorably and unfavorably under adverse possession. So I don't think there's a crisis around the application of the doctrine of adverse possession.
Okay, thank you for the clarification, Judge. And when we talk of adverse possession, which courts have jurisdiction over this matter? Because in some instances, we see people filing such cases before the magistrate courts or before the environmental land court. Which court exactly should be seized of jurisdiction?
Both courts do. I said earlier that the magistrates court have a pecuniary jurisdiction. So if the land is, say, worth more than 20 million and you want to claim adverse possession, you obviously cannot approach the magistrates court. You can go to the High Court, to the Environmental Land Court, which has a limited jurisdiction in terms of land. So I know there's been confusion over time on whether magistrates courts can handle land matters. The truth is now we have sufficient jurisprudence that magistrates court can handle land matters within their pecuniary jurisdiction. So it really depends on the value of the land. And then appeals from the magistrates court can go to the Environmental Land Court, which they can be determined on appeal. So both courts can handle land matters.
Thank you for clarifying that question on jurisdiction, Judge. And now let's look at these interesting terminologies in civil litigation, interested parties, and sometimes you also see amicus curiae. What exactly is the difference between these two? and what are their rights. And when I talk of the rights, I'm thinking of a scenario where you see an interested party seeking substantive orders, in their favor. Does it make them plaintiffs or defendants? And can there be a defense by an interested party?
Thank you very much. Let us dispose of the amicus curiae question. An amicus curiae, amicus is a friend, curiae is a court, so a friend of the court. And you only come as a friend of the court, and in the case of Mumo Matemu, the Supreme Court delineated the difference between an interested party and an amicus curiae. An amicus curiae is a party coming to the court as an expert to say, I have expertise in a particular area of law, which is the substance of the case before you. Allow me to bring my expertise to bear on the question. So they don't take sides. A friend of the court is a friend of the court, not a friend of the parties. So you're coming to help the court understand the issues better because of your expertise. That is amicus curiae. Put that aside. An interested party is a party that has a legal interest or an identifiable state of affairs in the case, and therefore comes to the court to say, these two parties that are fighting, the plaintiff and the defendant, although they are fighting about this land, I also have an interest in that land because the defendant sold a portion of that land to me. So that the interested party is not coming as a substantive party to the dispute, but is coming to say, I have an interest which also needs to be secured as the court determines the interest of these two main parties. Your question whether an interested party can file a defense or you cannot. In fact, one of the interesting cases that was controversial in the Supreme Court, which was misunderstood, is the case of Methodist Church of Kenya. And this is popularly called the hijab case. The reason why we dismissed that case at the Supreme Court is because we were saying the judge of the High Court saw a case between two parties, a plaintiff and a defendant. The issue of the hijab was not there as a substantive issue. A parent called Fugicha then filed an application to join the case as an interested party because he was a Muslim parent with two girls in the school. In paragraph 23 of his replying affidavit to the case, Fugicha introduced the question of whether wearing of the hijab is constitutional or not in high schools. And then the judge of the High Court took up that paragraph 23, and that became the substance of the case. And so he addressed the question of the constitutionality or otherwise of the wearing of a hijab. Hijab is a Muslim lady's cover on the head. The Court of Appeal did the same. At the Supreme Court, we said, look, an interested party cannot create a substantive case. So that the judges of the court below the Supreme Court ignored the issues which Methodist Church had brought and which the schools had brought, and then focused on a matter brought by the interested party. And therefore, the point I'm making is an interested party cannot take over either the plaintiff's case or the defendant's case because he or she is not the owner of that case. It's only interested in one side of the case. That is the difference.
Okay. Thank you for that clarification, Judge. And let's now move on to another jurisdictional issue, and this concerns matters of succession that also have a pending issue before the Environmental Land Court. How should lawyers and the public, handle this kind of matters, where you are dealing with a succession matter and you have a pending issue concerning the rights over that property before the Environmental and Land Court?
So let me give you an example of a typical situation like this. A lot of you may have heard of the Kirema family succession case, which I handled for almost 10 years. The family has a land in a place called Njiru in Nairobi, towards Ruai, I believe. And as the succession case was going on before me, people were being sold land within the Njiru land of the family. When they came to me, I told them my case is limited to succession. I cannot convert myself as a judge of the High Court hearing a succession dispute to also determine your claim to land. Because Article 162.2 stops me as a judge of the High Court from taking over matters in the jurisdiction of the Environment and Land Court. And therefore, what you should do, go and file your case in the ELC, obtain a judgment in the ELC saying you are entitled to 5 acres of land or 1 acre or half an acre, bring that judgment to me as a succession court judge. And as I distribute the estate of the deceased, I will take into account your judgment and the entitlement in the estate. So again, I see confusion where lawyers and parties go to the succession court and purport to attempt to prove ownership of land within a succession court. The succession court is not the ELC. And the High Court cannot take over the role of the ELC. So before 2010, and I was a judge before 2010, so I know this, a succession judge could handle any aspect of a dispute around an estate, including ownership of land. So at some point during succession hearings before 2010, I would sit and take evidence as to whether you, Dr. Evelyn, bought land from the deceased, and therefore whether that you are entitled to inherit part of the estate. Today, you cannot do that. And I think that ought to be clarified. Go and prove your claim in the Environmental Land Court. Bring that judgment, if it's successful, to the succession court, and that succession court has an obligation to ensure that your entitlement to the land forming part of the estate is done during distribution when the grant is confirmed by the High Court. That is the difference in how to handle these matters.
Okay, thank you, Judge. And now let's talk about boundary issues and the jurisdiction over these kinds of disputes. Judge, is it the magistrate courts who should have jurisdiction over boundary disputes because they have been delegated such powers under the statute, or is this an exclusive jurisdiction by the land registrar?
The land registrar has the primary duty under the Land Registration Act to demarcate, survey, and create boundaries for land. Mm-hmm. But the courts generally, whether it is the High Court or the Magistrates Court, have supervisory jurisdiction over that process. Similarly, you can appeal a decision or you can seek judicial review orders against a decision of the land registrar if you are not satisfied in the courts. So we have this concept that you must begin the process from where you should begin at. In the question of land, courts cannot start demarcating land. Court cannot start creating boundaries. No. So we tell parties, go to the land registrar and the land surveyors. Let them do the boundaries. If you're not satisfied, then come to the court for the court to oversee that process, confirm they followed the law, confirm the facts are right, and then determine the matter. So there should not be any conflict between land registrars and the courts in this matter. And again, remember, for magistrates court, depending on the value of the land. For the High Court, it's for the ELC, it's unlimited.
Okay, thank you very much. And now let's talk about jurisdiction over wildlife cases. Judge, maybe help us to understand, how should victims of wildlife attack access their justice? Should they pursue compensation claims, in negligence cases, or should they go before the committee established under the Wildlife Conservation Management Act?
Both. Procedure for pursuing compensation is provided under the Act, as you have said, Wildlife Coordination and Management Act. But the first thing to do under the Act is report to the nearest Kenya Wildlife Service office, or report to the nearest police station, and they'll guide you to where the nearest Kenya Wildlife Service office is. Once an incident report is prepared, it is then followed by a verification and assessment of injury. Once that is done, then you submit your report to the County Wildlife Conservation and Compensation Committee, which is in every county. And then recommendations are made by that committee to the Cabinet Secretary for Tourism and Wildlife, and it is the Cabinet Secretary and the Permanent Secretary of that ministry who then determine how do they get to pay you. I know that there are many complaints about people who have received favorable judgments. People have received awards. But in terms of real payment, families have suffered, including those who have been killed by wildlife, like elephants. If you are in that, if they don't pay you, they go by to the High Court and say, I have this award, I would like the permanent secretary to be cited for contempt, or for the court to make such orders it thinks fit to ensure that payment is made. So there is an elaborate process under the Act, but I notice also that people, because they don't know, they get conned by brokers. There are brokers who come and say, people, oh, you know, I work with KWS, pay me so much, and I'll get you your payment. I would suggest that anybody with an issue like this would either approach a lawyer or approach the Kenya Wildlife Service or approach the police, and then they'll guide you through the process until payment of your compensation.
Okay. Thanks once again. Judge, your comments on the elaborate procedure, requirements for compliance in civil litigation. Yeah, perhaps you can just briefly take us through a typical, procedural requirement for one to get their case into a civil case through the courts, and share your opinion or your views on what you think about this elaborate procedure. Yeah, and we have seen many advocates just taking advantage of this elaborate procedure to delay processes, asking more time, compliance. Do you think this is an impediment to access to justice, Judge?
I think in prior years, that could have been said that the elaborate process, the fact that lawyers understand the language of the law more than litigants, cannot access our registries to be told what their cases, what state their cases are at. But today, and I lead in this in the judicial and technology, you are able to get your status of your case with an SMS to your phone, so that in terms of access to justice, we are encouraging parties to get to know how they can receive information even without having to go to the registries or having to go to their lawyers. Issue number one. Issue number two, we have, as a judiciary, determined that there is a need for us to do both case management and pretrial processes in all our courts. This is a way of simplifying the processes so that once you file your case and service has been done and the other party has responded, and now it is a mentioned date to fix, to take directions on the case, we have told our judges and magistrates, be simple, be courteous, explain to people in simple language what they need to be doing starting from that date. This way, we allow parties to understand our processes, and then they don't get lost in the meantime. In the meantime, we also have open days in our courts where we allow the public to come to our courts, ask questions without even having a case, and that is part of our own CSR to ensure that litigants appreciate and understand what we do. For some years now, we have worked very hard to demystify the administration of justice. Previously, judges were seen as those guys in red robes who cannot be reached, who cannot be seen. Today, I think we are more humane, we are more understanding, and we are more accessible to the public in more ways than one.
Thank you very much. And you have mentioned the uptake of technology, Judge. Would you describe this uptake up to the required standards of client satisfaction?
So number one, with e-filing now, you can access your pleadings as a litigant. And so once you get yourself accredited to our system and you have a number and you can log into our system, you don't need to go to your lawyer or to the registry for you to enter the case if you are hearing the case virtually. Number two, you can also go to the system itself, and the system will tell you where your case has reached. Number three, I spoke about the SMS system, service, where you type into the system, and the case the SMS tells you how far your case has gone. Number four, we no longer keep judgments for more than 24 hours. So as soon as your judgment or ruling is delivered, we upload it on the system and you can access it immediately to know where it is. What I know we are still struggling with is, of course, issues of connectivity. And what we are doing is we are now ensuring that all the outer courts that have difficulties with network, we have modems, we have systems that can ensure that the courts sit virtually. We are also connecting with Huduma centers. So if you go to a Huduma center, you can be helped by someone who is there from the judiciary to know where your case is at. You can also just go to a cafe. When we launched the e-filing across the country, we also trained cafe owners, cyber cafe owners. So you can go to a particular cyber cafe and they guide you, both in terms of filing, also in terms of knowing the status of your case. So we are not yet where we should be, but I know that in the next couple of years, we should be so ahead. I can tell you this, in Africa, we are one of the most well-connected countries in terms of e-justice. And I lead in that, so I know that we are doing very well. We were in Hong Kong 2 weeks ago, and even the Hong Kong judiciary was shocked at how much Kenya is doing. We will do a lot more to ensure that our public, wherever they are, our people, wherever they are, can access our systems and get all the information they need at very little cost.
Okay, thank you. Let's now talk about case management. Yeah, many times, you see lawyers consenting with each other to seek for time extensions. We see endless applications from lawyers. And so we find our judges and magistrates being preoccupied in dispensing with interim applications, instead of, dealing with the issue at hand. Judge, what does the court do to ensure effective case management? And how do you tell that this is a frivolous adjournment?
So we now have in the judiciary something called a judiciary dashboard. The dashboard is a daily record of what is happening in our courts. So I can very quickly, even now here, go to the dashboard and know in Kakamega law courts today, which magistrate adjourned cases and why. I can go to Kitui and ask which magistrate adjourned cases and why, or which high court judge did the same. So what we are doing is we are using technology to encourage our judges and magistrates to be more strict, because if your record shows that you are very easy to grant adjournments, it will be against your own record. And when you do the performance management at the end of the year, you rank lower than your colleague who's tougher, who's firmer, who's easier to see that he's not letting frivolous adjournments work on you. But more fundamentally, we are having court users committees. We have bar bench committees. In those committees, we have conversations with our lawyers, with our court users, and we are telling them we cannot afford to keep adjourning cases because there is a consequence to you as a party and also to the advocates if you are perpetually adjourning cases. So it is a conversation we are having. Court management is a very personal thing to the judicial officer, to the judge. Some are very easy to be convinced, others are not. But we are also learning to create a balance, to do justice. So that if somebody has adjourned a case 10 times, or a case has been, you know that we no longer allow any case to stay beyond 3 years. So if your cases are perpetually being delayed beyond 3 years, even your promotion will be affected, because those records will go to the Judicial Service Commission and you'll be told, but you're a lazy bone. All your cases are 5 years old and then moving. So there are many ways in which we are assuring that both the public, the advocates, court users, magistrates, and judges work together to ensure that justice is done, because justice delayed is justice denied.
Thank you very much, Judge, for that clarification. And now let's turn and look at the costs involved in civil litigation. Judge, what would be your comments, especially when you look at cases involving indigent complainants? Would you say that this is an impediment to the access to justice?
I think that is an erroneous judgment, because we have systems we have a law under the Civil Procedure Act where indigents can come to court and say, I cannot afford to file filing fees. Give me an order where I can file my pleadings without having to pay fees. And a lot of paupers have come to court and they've been heard. In fact, right from the beginning, from the application to seek to be exempted from paying fees, we have issued those orders as far as the Supreme Court, so that all one needs to do is, if you're an indigent, if you're unable to pay fees, go to our registries, they'll guide you in how you do it. But if you can't afford it, then of course you will pay the regular fees under our schedule of court fees. Frankly, today, we do not have as inhibitive costs of filing fees as we used to have in the past.
Okay, let's talk about the importance of
Let's speak about the related costs, not just the filing fees.
filing. Okay.
You know, today, because of technology, we are now not having people walking distances, paying transport costs to come from Samburu to Nairobi, from Kitui to Nairobi, because your case can be heard where you are.
Yeah.
Or if you don't have the system to hear your case, go to the nearest court, then you'll be linked to the court where your case is at. At the Supreme Court, we've had people who have sat in Bomet, in Kisumu, in Mombasa, and we've had them because they can't afford to travel to Nairobi. So again, the fact that we are digitizing our processes means that the cost of litigation is becoming much, much smaller.
Yes, yeah. Thank you. Now let's talk about evidence gathering and production in court. In a scenario where a litigant does not have original documents, how does the court guard against miscarriage of justice, where the only documents available, Judge, are copies of the originals, and it's becoming almost impossible to access the originals?
Sadly, our system is adversarial, so that he who alleges must prove. If you are the one who says that B has committed a legal error and that your documents are the valid documents, you cannot bring photocopies unless you can also bring evidence that you're unable to bring those originals. There is a system called production of secondary evidence. You must then go through the procedures to show why you cannot produce the primary evidence, but you can produce the secondary evidence. So sadly, in our system where which is adversarial, we are not at a stage where you can bring photocopies of photocopies of photocopies and claim that that is the only evidence you have. You must show why you cannot produce the originals.
Okay, and now let's talk about release of exhibits, to complainants upon settlement of the disputes. Judge, what would be your view about items of value that deteriorate with time?
So what happens is that if perishables or items of value that deteriorate with time, normally what the courts do, especially the magistrate court, is as soon as the evidence is tendered and it's seen and it's recorded, then the court can make an immediate order that this evidence is released to the owner. For example, suppose you are the complainant in a case of motor vehicle theft, and your vehicle has been taken to the police station, it has been brought to the court, it is parked outside at the court parking, the court has walked from the courtroom to the parking to see the vehicle. Then ordinarily what happens is that the prosecutor will say, Honorable Magistrate, now that we have seen the vehicle, we have taken pictures, we have produced the pictures as evidence, you have seen the vehicle, you have seen the pictures, the same vehicle, let us release the vehicle to the owner. That is done. The same thing that is done with the identity cards, wills, academic certificates, title deeds, documents that are of importance, which may disappear in the court registry, ought to be released as soon as they're produced as evidence. And once they're recorded as such, then they are released. And that happens every day in our courts.
Okay. Thank you for educating us on that. And then let's now turn to structural interdicts in magistrate courts. What would you like our young advocates to know, as well as the magistrate courts, about structural interdicts in magistrate courts, because we find it a very common practice where advocates, sue in different courts, trying to enforce a court's judgment.
So structural interdicts are also called supervisory orders, where a court is saying, although we have issued a judgment in a particular case, we think that we must supervise the enjoyment of that judgment by one party. Let me give you an example. And I think that was the first case where a structural interdict was issued at the High Court by myself. In the case of Satros Ayuma versus Kenya Railways, the apartments in Mudurwa, when I delivered the judgment, the issue was again what you raised at the beginning about evictions. And when I wrote a judgment where I gave conditions for eviction of those people who are in the apartments. But I also said that the court must supervise the evictions so that every so often I would receive a report from the Attorney General and the railways lawyers saying what they've done towards the eviction of those people who are to be evicted from those premises. We also wrote in the Mutual Welfare Society case at the Supreme Court, we gave conditions where structural interdicts can be enforced. It is not wrong for magistrates courts to issue structural interdicts. In fact, in India, where we borrowed that system, every court from the district court to the Supreme Court could issue structural interdicts. But I noticed that in Kenya, mostly because they do not know, a lot of magistrates courts do not issue structural interdicts. At the same time, I know that magistrates courts are so busy that they want to get files out of their hands, so that how would you, I see magistrates would not want to have a judgment which then is given, but the file comes back to them to supervise the enforcement of the order. So I understand why, but in fact, in law, in jurisprudence, it is not wrong for magistrates courts to issue structural interdicts, the way the High Court does, and the way the Supreme Court does, and the way, incidentally, in the Muratotu case, the orders in the Muratotu case, the Attorney General qualify as structural interdicts. So all the Supreme Court, any court can issue structural interdicts.
And as we finalize, Judge, what are some of the common mistakes that you have seen throughout your period on the bench that young lawyers make and that you would like them to rectify in terms of procedure, in terms of substance? What are these mistakes that you have observed on the bench?
Next time you call me for me to speak on what I call the 25 mistakes lawyers make in court. I have a paper on that, and I spoke to the Law Society some years back on that specific subject. It's a very long subject, but let me just pick on three. The first is poor drafting of pleadings. The beginning and ending of a case is how you draft your pleadings. If you draft your pleadings badly, you probably get a bad judgment. So I keep telling lawyers, whatever you do, my friends, prepare your pleadings well. Don't rush into delivering to court a half-baked sort of pleading, 5 paragraphs of a plaint, 10 paragraphs of a defense. You will begin and kill your case at the point of pleadings. Number 2, please be, and this is a recent phenomenon that I'm seeing. I'm seeing mistakes being made by young lawyers, especially, who rush into ChatGPT, collect all these niceties from ChatGPT, not knowing that ChatGPT is prone to multiple hallucinations. Just the other day in Nakuru, an advocate went to court and the judge told him, go and file submissions, come back in 7 days. He went to his associate, who dashed to DeepSeek, got very beautiful submissions, took them to his boss at 4. The boss read them very quickly, was very happy, and told him to file on the online system. At 5 p.m., he received a call from his colleague on the other side, who told him, thank you very much. You filed the best submissions you could ever file for our client. They filed submissions for the wrong party. So again, be careful. When you use the artificial intelligence, when you use technology, when you do cut and paste, I also noticed that there's a lot of cut and paste pleadings. And when you cut and paste pleadings, you make mistakes because sometimes you leave a whole paragraph in the first case into the second case, and you may not get the opportunity to amend, and your case dies. Number 3, when you come to submit, submissions. When you are told, please highlight your submissions, please highlight your submissions. I know people who come, try to read word by word, and they get lost because they don't take advantage of the fact that your submissions are already on the court record. The judge or magistrate has them. What you need to do in highlighting is hammer, pinpoint on the stronger points of your case orally. People lose that opportunity by coming to read as if I don't know how to read. There is a presumption a judge or magistrate knows how to read. So you come and tell me, my lord, at paragraph 5, I have said. Then you read what you have said at paragraph 5. My lord, at paragraph 15, I have said. Who tells you judges and magistrates cannot read? Highlighting means you hammer on the stronger points of your case. That is how cases are won. Those are 3 of the 25. Next time, call me to speak about the other.
Yeah, we will discuss all the rest next time. And now let's turn to the questions in the chat box. Question number 1 from Sheila Bahati. How can Kenya handle a situation where person A and B, both of the same gender, married, visit Kenya using the same insurance, but Kenya only recognizes couples of the opposite gender?
Let me take 3 or 4, then I can answer them together.
Okay, then the second one, if the hospital refuses to accept the insurance, can they petition to have it accepted? Remember, they come from a jurisdiction that allows same-sex marriages. So this is basically about same-sex marriages. Then the second question from Wakili Ole Lesere, can the Honorable Judge elaborate on indefeasibility of a title in Kenya? Third question, Ayaga Max, very apt and succinct analysis. Okay, this is not a question, sorry. The other question is from Freddy. What's the judge's opinion on the Court of Appeal judgment that the lower court do not have jurisdiction on adverse possession? Maybe you can take those 3.
Yes. So let me begin from the same-sex unions. For as long as in Kenya we do not accept same-sex unions, which we do not, because we have not quite gone to the situation where we have struck out the sections of the penal code that criminalize same-sex unions. I know that there's a case in the Court of Appeal where parties are trying to have those sections decriminalized. You also know that in our judgment in the Eric Gitari case, we at the Supreme Court said that lesbians and gays and the others of that category have a right to form their own on their own. So for me, the position here is that for as long as we do not accept such a union, I'm afraid you have to get individual insurances. Each of you gets their own insurance, not one that covers both you as a couple. That is our law. In South Africa, it is different. In the US, it's different in some places. But for the time being, that is our situation. Feasibility of title in Kenya, I think I know where this question is coming from. Before 2010, when we got the constitution, there was this policy of the law that which also based on the Registration of Lands Act, RLA, I believe section 23, that if you are the first registered owner of land, then whether you obtain that land by fraud or misrepresentation, that title can never be challenged. I think we have now gone beyond that because of the nature of our constitution and the land laws that we have. So that in DINA management, we have DINA management Torino cases. The Supreme Court has said, we must interrogate the root of your title. So that if your title was obtained unlawfully from the beginning, then it was unlawful at the beginning, it cannot be legalized merely because of title. And so the law today, as settled by the Supreme Court, is that title is prima facie evidence of ownership, but it's not absolute. So that if somebody can show, as was done in DINA management, that your land was obtained fraudulently, as President Moi did in dinner management, then I'm afraid the question of invalidity of title is no longer as it was before 2010. The last question on adverse possession. You must understand that the Court of Appeal has its own view of the law. You know that, for example, in the arbitration cases, the Court of Appeal disagreed with itself in many a time. So one bench would say, in new to aggravate, you cannot appeal arbitration cases from the High Court. Another bench says in synergy, you can appeal to the High Court. These are issues that can only be settled by the Supreme Court. So that if there is a disagreement, because I also know judgments of the Court of Appeal which say that adverse possession can be addressed by magistrates' courts. One of the jurisdictions of the Supreme Court is to settle confusion of the law created by the Court of Appeal having 2 or 3 different views about a particular question of law. So I've given you my view, and I know I am saying that. If a judge of the Court of Appeal has a different view, that is their view. If the matter comes to the Supreme Court, I'll render myself as I wish at that point, and depending on the circumstances of the case. If it doesn't, sadly, you have to live with the judgment of the Court of Appeal as the final court in the circumstances. If you ever find 2 judgments of the Court of Appeal that are conflicting, choose the one that favors your client more. There is nothing wrong with you saying, in the Court of Appeal, in this judgment, they have said so, that's where my case dies, and you follow that case. Let the Court of Appeal then determine whether they agree with their prior decision or they don't. But this is a common thing in all the courts of the level of the Court of Appeal. But until the Supreme Court speaks, then you have to suffer with whatever the Court of Appeal says.
Okay. Thank you. We have another question from Bradley Liodo. Suppose after the judgment of the ELC, an appeal is filed, what happens to the succession case? Doesn't it have to wait for the appeal to be concluded?
Okay. Yes.
Then the other question from Michelle, what is the judge's view on the new bill signed by the president about the jurisdiction of issuing the leases of a land, especially in the case of Jamhuri?
And third one?
The third one, on stare decisis doctrine and its raw application. Are we sacrificing creativity and innovation by judicial officers at the expense of promoting consistency and predictability? How do we strike a balance?
So ELC and the succession cases, the proper thing to do ordinarily would be where there is, for example, an appeal against a decision of the ELC on a land question that also affects a succession case. The best thing to do ordinarily would be to stay the succession until the land matter is settled, then the succession can start. And that is a common occurrence in our courts. Just justify to the succession court judge why you must stay the succession case. So you're right. On the leases question, I'm a bit uncomfortable answering it. I know that these questions are going to go to court, but I just want to say that there may be confusion, incidentally, on whether, in fact, what we are seeing in social media is the true law. Be careful whenever you see what are they called? They're called screenshots of legislation which does not have the full text. I keep telling lawyers that we are becoming subject to social media lawyers who may not be lawyers themselves. Before you make a decision as to the legality of anything, go to the source. If it's a bill, go to the Kenya Gazette, look at the bill. And I know that, for example, this land issue, I've seen people picking some old bills which have certain provisions which never went through to become laws, and then they're circulating in social media as the law. Please be careful as lawyers. Don't fall prey to that kind of thing. But I know that this matter is in court, as are the cases around the Cyber Crimes Act. They may come to the Supreme Court. I cannot at this point express myself, although, of course, I have a view about those matters. Or stare decisis, sadly, the stare decisis is all about consistency of the law. It's all about clarity of the law. So that if you use what you are calling innovation, creativity,
Yeah.
to create your own law, we are just going to have chaos, because assume every magistrate in the 47 counties writes a different judgment around one issue of law. Where will we be? Suppose the Court of Appeal decides, sometimes it does, the Supreme Court is not too serious and they decide to do their own thing. Suppose the ELC or the High Court decide the Court of Appeal are not serious, they do their own thing. We shall create complete chaos in the administration of justice. And therefore, I'm afraid we have to live with stare decisis, because that is between the two choices, chaos or stare decisis. Balance lies in applying stare decisis.
Okay. The next question from Eric Kibogo. In practice, is a decision of the Supreme Court binding on itself? In theory, I know it isn't. For example, Supreme Court petition number E035 of 2023, the right of children born out of wedlock, I think. Can the Supreme Court review its decision when moved? Second question from Lekindi. What is the judge's position on the applicable law for judicial review proceedings now that the Fair Administrative Actions rules have been suspended? Does this mean we revert to Order 53 of the Civil Procedure Rules? Then we have another question from Michelle. How would you deal with corruption? Suppose they're dealing with sensitive cases, for example, in cases of rape and murder, but offered with the ransom money by the accused person.
Okay, so I greet you, Eric. I know you. The truth is that the Supreme Court of Kenya, in its 13 years of being around, has never had an opportunity to overturn itself. For example, what the Supreme Court of the US has done in Roe versus Wade. And the reason is, and I tell lawyers this, it is not enough to say the Supreme Court should overturn itself. You must begin by asking the question, how does the Supreme Court overturn itself? The Supreme Court cannot overturn itself willy-nilly. It means that you must bring a case which is of the same facts and circumstances and law as a previous judgment, and in the second case, show the Supreme Court that it was wrong in the first one. So I've seen people assuming that the Supreme Court can sit on its own suo motu and decide we shall overturn ourselves in the children born out of wedlock judgment. You cannot do that. The procedure is that a different case will come of the same kind, say children born out of wedlock. Then the Supreme Court can say to itself, listening to the arguments in this case and being told to overturn ourselves as we are, and looking at our decision in the prior case, this is a fit case for us to overturn ourselves. So that is a procedure, and nobody has come to the Supreme Court using that procedure since 2011. And so yes, for as long as we don't have any case that forces us to overturn ourselves, then we are stuck with our prior decision. I've also seen that there's a misunderstanding about the review procedure of the Supreme Court. In the Outa case, we gave the conditions for the Supreme Court to review itself. Sadly, again, we have hardly seen anyone who has come properly for us to review ourselves, except in one small matter where Okoiti Omtata came and we reviewed an order where we had punished him for costs in a public interest case. Otherwise, no other case has succeeded because parties don't seem to understand, and advocates are not guiding parties to say, what does review mean? So parties come on appeal to the Supreme Court on a judgment by the Supreme Court. So they repeat the same arguments and tell us we are wrong by way of review. That cannot work. It has not worked. So let's be careful with that. Judicial review. There are three things about judicial review we must understand. Number one, there is judicial review prior to 2010 under Order 43 of the Civil Procedure Rules. There is judicial review under the Constitution now that I believe Article 20, is it 21 or 22 or 23? So that one of the remedies that is given to you as a litigant under the Constitution is under Article 23(3), an order of judicial review, F, so that you must appreciate that judicial review under Article 23(3)(f) is now a constitutional remedy, which is not a civil remedy under Order 43. Then Article 47, with or without the rules, has specific rights that it gives so that administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. With or without the rules, you can enforce Article 23(3)(f) together with Article 47. So the rules don't tie you to the enjoyment of the rights under the Constitution. So we must appreciate that difference. And I also see that parties have misunderstood our judgment in Praxidis Haisi, our judgment in Edwin Dande, and our judgment in, well, those two. We try to clarify Order 53 judicial review and Order 23 and Order 47 judicial review. If you choose to go under Order 43, then you are stuck, and Section 8 and 9 of the what is the act called? Law Reform Act. If you go under those sections and that order, then you are stuck with the traditional judicial review remedies of mandamus, prohibition, and certiorari. And therefore, we can't go into merit-based discussions. But if you come under the Constitution, then you go under merit. So that's a difference, and I don't know why parties don't seem to get it right. On corruption and rape. Now, many years ago, when I was a judge in Meru, I was very surprised when the head of the prison came to me and told me, Judge, the prison is full. You magistrates and judges are filling our prison with petty offenders. And I said, such as? He said, look at the rapists, they're all here. And I explained to him how rape cannot be a petty offense. Yeah. Neither can defilement under the Sexual Offences Act. So one of the mistakes that I see parties doing in the villages is that they are allowing Article 159 to be invoked to settle cases such as rape and defilement. That is completely wrong and morally wrong and legally wrong. So that if anybody uses Article 159 on mediation, arbitration, traditional dispute resolution mechanisms to settle rape cases, that is wrong. Number two, you have seen that the Supreme Court and the Court of Appeal are in a jurisprudential fight, where the Court of Appeal is saying the Sexual Offences Act, following Muratetu, a judge can reduce what is the minimum sentence to 5 years or 2 years of sentence served. And the Supreme Court is saying, no. You cannot apply Muratetu mutatis mutandis to the Sexual Offences Act because Muratetu was specific to what it applied to. The same thing with the life sentence. We are saying Muratetu never said that life is 30 years or 40 years. So again, jurisprudentially, we are having this conversation amongst the courts, and I would not want any of you to believe that what the Supreme Court says can be overturned by any court. Ultimately, whether you like it or not, the Supreme Court is a final court in these matters. Next.
Next question from Michelle. Please inquire whether they offer any financial helps for less fortunate students in the university, considering you are an alumni of UON. Is there sponsorship available maybe? Then Peter Njenga, how do courts approach novel issues where there are no statutes or legal precedents? Today, crypto and decentralized finances. And then our last question is Elvis Jomo. Given that the United Nations supports same-sex marriages and Article 2.5 of our Constitution does not recognize some international laws and norms as part of its laws, how do courts litigate such issues?
So financial help to students, I don't know who, when she says you, is it me, the judges of the Supreme Court, is it? What I know is that there are many of us who have helped students at the University of Nairobi and elsewhere to get education. I have many mentees who have educated right through law school. Perhaps if you're in a situation where you need me to assist, speak to Dr. Evelyn, and I can see what to do with that. And also have my friends who assist me whenever we have students that we need to pay school fees for. So I can be of help in that regard. Novel issues. The reason we are judges and not fishmongers or cattle rustlers is because we are trained in making judgment. So that whether there is a precedent or whether there is a precedent out of this country or whether there is another area where you can fall onto, a judge is trained to know where to find the law. So that when I was at the East African Court of Justice, one of the debates we had was whether the East African Court of Justice could use domestic law precedents to make decisions interpreting the East African Community Treaty. Or should we formulate our own judgments without reference to other laws? And the truth is that we decided we could decide our cases using any kind of law, any kind of precedent. The same with the Supreme Court of Kenya. The only thing we don't do, of course, is we do not use judgments which are on appeal. So that if a judgment of the High Court has gone on appeal, we'll have to wait for the appeal to be finalized for us to ever use it. But largely, we are trying at the Supreme Court to develop our own indigenous jurisprudence based on our own circumstances as a country. Our constitution is unique to us. Our laws are unique to us. We like to develop our own laws which speak to our own situation. But I can assure you, if you ever become a judge, you will never miss a law that supports your position. And if not, make your own law. Judge-made law is real law. And you know that from your training. I'm surprised about the same-sex marriages, why it's coming back again. But like I said earlier, I believe section 276 or 267 of the Penal Code, which criminalize same-sex conduct. You're aware that there is an appeal at the Court of Appeal where those two sections are being challenged. And the intention ultimately by those who practice same-sex is that once those two sections are decriminalized, then the next thing is to say, then we can have same-sex rights. So that is how it's going. Whether the Constitution allows it or not is a different question. We cannot, my friend, even applying Article 2.5 and Article 2.6, invoke a law that may be against our own Constitution. When we're writing this Constitution, I can tell you, because I was there, Article 27.4, which is about non-discrimination. Article 27.4 reads as follows. The state shall not discriminate directly or indirectly against any person on any ground, including race, sex. Between sex and pregnancy, we had initially inserted the word sexual orientation. Our intention then as drafters of the Constitution was to ensure that this issue would not arise post-2010. However, those two words, sexual orientation, were removed long before we came to Bomas. So you need to appreciate that we attempted in 2007, 8, and 9 to bring those words. But if you look at the Eric Gitari judgment, and you're aware that I was involved in that judgment, we then said Article 27.4 is not exclusive of grounds for discrimination. It is inclusive, and therefore, that is why we said you cannot use this section, neither can you use section 30, any other article of the Constitution, to say that gays cannot register an association of their own. So these are progressively realizable rights. Your generation is comfortable with same-sex unions, and I know a lot of people are living in Nairobi together, even if they're not registered. We know that. But my generation is still very uncomfortable with it. So over time, these matters will be clarified by courts, as like I said, in the judgment that may come very soon to the Supreme Court after the Court of Appeal has rendered itself. Thank you.
Okay, thank you. And my last question from Evans Nzinga. Can an administrator distribute property to beneficiaries when there is an active succession case in court? I think you have talked about this.
No. Section 45 of the Law of Succession Act states that any person who attempts to distribute, I'm paraphrasing, because the section is about intermeddling with the estate of a deceased person. Any person who attempts to distribute an estate while there's a pending succession case is committing both a civil offense and a criminal offense. And in fact, the Law of Succession Act in that section has a criminal sanction for anybody who distributes an estate before the court has done so. So that is a clear matter in the law. Read section 45 of the Law of Succession Act.
Okay. Dennis Orobo, please pass by my hearty congratulations to the judge for the good work he is doing as an NCAGA chair on ICT. I'm super proud of you. Eric Kibogo, such brilliance, I covet. Thank you, learned judge, for sharing your wisdom. Another one from Sheila. Many thanks to the Honorable Judge, Lenaola, and Dr. Sala for today's session. We hope to see you again on the next session. So, Judge, I think this is the best place to end our talk today. And you can see how excited our viewers are about your talk and your engagement and even your accessibility. You know, not many judges are accessible, you know, for this kind
You know, you got me to, after a very busy day. Well done.
And your day is very busy.
You really got me here screaming and kicking, but I'm happy I came.
Yeah, and we are really thankful. We truly appreciate and we are honored to have had you tonight. So thank you very much, and this brings us to the end of the day.
Thank you very much, everyone, and good luck. Bye-bye.
And yeah, let everyone subscribe so that we can notify you when the judge is coming next time. Thank you.